Hello and welcome to Macros with Mythili, the ET Now show that takes a hard look at all the major macroeconomic issues and developments in India and overseas. In this edition, we're going to take a hard look at the Fugitive Economic Offenders Ordinance 2018. The law that came into force, the President giving his assent to the Cabinet's decision to pass such an ordinance, is being touted by the government as a fitting answer to the phenomenon of loot and scoot of powerful white-collar criminals, the likes of Vijay Mallya, Lalit Modi, Nirav Modi and Mehul Choksi, defrauding and then escaping justice by fleeing the country. But is this kind of magic wand? Is the new law all that it's made out to be? What are the chances that these individuals and indeed future crooks will not be able to escape the long arm of the law, or that it will defer white-collar crime in future? Joining me in the discussion are Mr. M.R. Umarji, former Executive Director, Reserve Bank of India, who had a long innings in commercial banks before moving to the RBI, and Ashutosh Dixit, Joint Secretary, Ministry of Finance earlier and presently partner Deloitte India. Welcome to the show, Mr. Umarji, Mr. Dixit. My first question to both of you is about the appropriateness of the ordinance route. The Fugitive Economic Offenders Bill was introduced only as recently as March 2018. And given that perhaps we have had much more important bills, maybe like the Women's Reservation Bill that has been waiting for clearance for so many years, and the government has not thought it appropriate to bring in an ordinance, does it appear that there has been some undue haste in this context? Yes, the Constitution Article 123 does have a provision for issue of an ordinance, but this is a provision that is to be used only in very special circumstances, when Parliament is not in session and the President is satisfied that circumstances exist that render it necessary for him to take immediate action. Did the present circumstances really warrant such immediate action, or should such important legislation be passed only after debate in Parliament? Let me start with you, Mr. Umarji.
In my view, one of the reasons why this has been passed as an ordinance is that some of the offenders are not appearing before the court, are evading arrest, and it is to take action against such persons that it is passed as an ordinance. Now, having done that, there are certain provisions which seem to be draconian, harsh against the persons, and how they will be implemented in practice has to be seen.
Okay. Would you agree with that view, Mr. Dixit? We'll discuss the provisions later, but was there, as government has argued, really a pressing need in view of the number of bank frauds that have recently come to light? Or was the need more political rather than economic, given that the general elections are looming ahead? Economic offenders are not new. We've had Vijay Mallya, Lalit Modi, for instance, and they've been in the UK for many years now. So what was the urgency? After all, Parliament will be meeting for the monsoon session in just about 3 months from now. So could he not have waited?
So my view on this is that this reflects the policy imperative of the government, and if I look at the broader macro picture, then the credit system in India is currently under a lot of stress, and it's public sector banks which have been the bulwark of credit creation in India. And we know that there have been policy initiatives by the government, including the insolvency code, as well as the rapid recognition of non-performing assets of banks. And this could also be looked at as one of the other ways in which the sector needs to be reformed, because in all those other cases we are talking about credit which has gone bad, but then there is also a subset where a credit may have gone bad due to a fraudulent action. And the government seems to have been hamstrung by the fact that they could not take action in such cases because they were not able to get the presence of the accused or the so-called offenders before the courts. Also the statement of objectives in this bill actually specifically mentions that most of such cases of economic offences involve non-repayment of bank loans, thereby worsening the financial health of the banking sector in India. So that seems to be the imperative of the government in getting this through as an ordinance, rather than waiting for it to be passed as an act in a subsequent session of Parliament.
Mr. Umarji, the press release on the ordinance says, and I quote, "Existing civil and criminal provisions in law are not entirely adequate to deal with the severity of the problem." Would you agree? One would have thought that the provisions of the Prevention of Money Laundering Acts, FASE, and more recently the Insolvency and Bankruptcy Code are more than adequate to deal with financial or white-collar crime. And the problem is not so much lack of laws as poor enforcement and legal delays, for which the answer really does not lie in more laws. Mr. Umarji?
I agree with this view that you see the law is supplemental to Prevention of Money Laundering Act. There is a provision for confiscation of attachment of properties involved in as proceeds of crime under the provisions of PMLA, where there is an adjudicating authority to be appointed. He gives a notice to the concerned individual after hearing him and giving him an opportunity to establish that the property is not created out of proceeds of crime. Whatever defense he has, he is allowed to put forth. After examining all the facts and circumstances, the adjudicating authority has to come to a conclusion whether the property or the funds or whatever other assets available are proceeds of crime. And after coming to a conclusion that it is proceeds of crime, there is a power to issue attachment order. There is no confiscation of property. The confiscation of property comes only after reaching a conclusion that the individual is guilty of commission of a scheduled offence as prescribed in the schedule. In this law, that procedure is not elaborately provided, and the declaration that the property is acquired by proceeds of crime and is needs to be attached, the attachment order is issued, and once the conclusion is reached that it is the property is acquired by commission of an offence mentioned in the schedule, then there is a order for confiscation of property passed. Actually, the section says that the property shall stand confiscated. That is, on passing at an order, the order of confiscation itself becomes effective. Now, this again is without any opportunity to show cause and all that. I have my concern as to how it will actually get implemented in practice.
Absolutely, which is why we are worried, because it might turn out to be far more draconian than perhaps even the government intended. But Mr. Dixit, let me ask you the same question. Is it lack of laws or something else, the legal system in our country for instance, the inability of the Economic Offences Wing and the Serious Fraud Investigation Office to be able to build a strong case? And here does the problem also lie with the fact that the SFIO doesn't really have a dedicated, specially trained cadre that really understands white collar crime. Milind Deora, the Congress MP writing in the Economic Times, says that unlike earlier laws such as PMLA, where attachment of assets is a putative measure, under the new law, this will act as a deterrent. I frankly don't see the difference. Do you, Mr. Dixit?
So, again stepping back, you see globally there are two kinds of forfeitures and other laws, which is one is as was being talked about currently, which is already there in the PMLA, which is criminal forfeiture. That someone's once having been convicted for money laundering, the assets can be subject to forfeiture. There is another which is the non-conviction based asset forfeiture, and that is what is being talked about here. And that is essentially in these laws, in many of the countries, this non-conviction based asset forfeiture is a part of their anti-money laundering legislation, where if somebody escapes the jurisdiction of that country or flees from it, then you can have an asset for forfeiture, because that person would not actually ever be convicted under those particular provisions since he is absent. So the United Nations Convention Against Corruption, which India ratified in 2011, has a specific article which talks about this non-conviction based asset forfeiture. So this is something which is there in legislations in other countries. In India, it is there in bits and pieces in the Criminal Procedure Code, but then there are issues with regard to how that actually can get implemented. So the introduction of this either as a standalone legislation or as could have been as part of the PMLA is in line with what such legislation exists in other countries. Coming to the implementation of laws in India has always been an issue. The lack of implementing authorities, the fact that they are understaffed, and also the lack of judicial forums as well as the manning of the judicial forums, that is an issue which goes across in the implementation of a number of our economic legislations.
Yes, which is why the worry, even though India may not be an outlier in having such a provision, given how laws are implemented in the country, a lot is left to be desired. But Mr. Umarji, if I can come to the specifics of the ordinance, a disturbing aspect really of the new law is that it allows attachment of the fugitive economic offender's assets, not only before conviction, but even before filing the application before the special court, to have the person declared a fugitive economic offender if the authorized official feels a need. Does this appear to be a travesty of justice, and could the provision be misused to harass Mr. Umarji?
The objective is also, you see, there is also another provision which says that if the person comes and appears before the special court, all the proceedings will come to an end. The proposal to declare him as a fugitive offender and all that. So, therefore, the object is to compel a person to appear before the court and cease to be a fugitive. That is the purpose of making this provision, and there could be cases where there is a valid reason or justification for person's inability to appear before the court, that it is for him to defend himself and explain to the court, etc. And if the property concerned is not a proceed of crime at all, it is something totally different, all such issues can always be taken up with the concerned authorities and explained. So, that is the reason why this provision is made, but it is no doubt harsh, and particularly saying that the property stands confiscated is is a provision which is resulting in depriving a person of his property rights without giving him a show cause notice and all that. So, that again is a little draconian provision in the law.
So, as of now, the provisions do seem a little harsh, and maybe when Parliament takes it up for discussion, they will be watered down. But I am afraid it is time for us to slip into a very short break, but please do stay with us. We will be back very soon. Welcome back. You are watching Macros with Mythili, and I am in discussion with two experts, Mr. Umarji and Mr. Dixit, on the government's recent ordinance on fugitive economic offenders. Mr. Dixit, the ordinance defines a fugitive economic offender as a person against whom an arrest warrant has been issued in respect of a scheduled offence and who has left India in order to avoid criminal prosecution, or being abroad refuses to return to India to face criminal prosecution, and then lists a number of scheduled offences that come under its ambit. It also gives search and seizure powers to designated officials merely on the grounds of suspicion, and that, as we all know in the context of the Income Tax Act, has often been used to harass. How can we ensure against similar misuse?
So, on this, what could be the safeguards? Those safeguards essentially what are currently there under the Prevention of Money Laundering Act and the administrative processes. One would expect that those safeguards are in place. But just stepping back here, in all of these cases, even if an application has to be moved on the suspicion that somebody is a fugitive economic offender, in that case also I would expect that an arrest warrant should have been issued on that person, and that person, as you just gave in the definition, and despite that arrest warrant having been issued in respect of that person is not coming and presenting himself before the designated court. The other thing is that, as you mentioned, that there are a schedule of offences with respect to which somebody could be declared a fugitive economic offender, and in that schedule, one is of course the Prevention of Money Laundering Act, but then there are another 8 or 10 acts which are mentioned, which are currently not under the Prevention of Money Laundering Act. So, to that extent, the scope of declaring somebody a fugitive economic offender widens beyond the PMLA, and the reason for that seems to be that in all those cases also conviction would be difficult for the prosecution unless that person presents himself before the relevant court.
Mr. Umarji, would you agree that the ordinance as it stands is far too sweeping in its scope? Because among the offences listed in the schedule, there is one relating to dishonour of cheques under the Negotiable Instruments Act. And that is particularly troubling given that cheques can be dishonoured for a variety of reasons, not all of which might have fraudulent intent. In fact, cheque dishonours have hugely added to the burden of the backlog in courts. So are we in danger of carrying things too far? Should the law have been more limited in its scope? Mr. Umarji?
Yeah, that's true. A dishonour of cheque is also there. I was not very sure about that. That offence of dishonour of cheque is only to give a sanctity to issue of cheques, and there could be many valid reasons for not honouring the cheque, and it's not correct to declare inability to pay a crime. Actually, it's making, you see, we are reaching a situation where you borrow money from the bank and you have to repay that money. If you are unable to repay, you are committing a crime. This is something is very harsh, and unless it is established that you have committed a fraud, you have borrowed money with intention to cheat, you have borrowed money with intention to use those funds for some totally different purpose and not utilize it for the purpose for which bank has given the loan. Unless these facts are established, the person should not be held guilty of any criminal conduct on his part. And mere dishonour of cheque could be, there could be a genuine case that I have to pay housing loan installment and I lose my job and I am unable to pay the next installment, and the cheque is already issued, advance checks are given to the banks, and then there is a default. And there could be some genuine reasons like this, and I think it is becoming very harsh to include such kind of offences under the schedule to the new law.
Yes, it does seem a little harsh, but we must remember that this covers offences of over 100 crores. So things like dishonour of a housing loan cheque, those will not get covered, but even so, a cheque could be dishonoured for a variety of reasons and does seem a little harsh. But Mr. Dixit, the ordinance also says that the attachment of property will continue for 180 days or for such other period as may be extended by the special court. As a former revenue official and with extensive experience in the finance ministry, you have long experience of how our courts function. So for all practical purposes, the attachment could be for much longer, and merely on a doubt or a suspicion, call it what you will, because conviction may take years, even with a special court. Mr. Dixit?
So on this, let me just point out that that this legislation's purpose seems to be only to procure the presence of somebody who's accused against whom a warrant of arrest has been issued in case of an economic crime. And as you mentioned, the scheduled offence, the amount is in excess of 100 crore. So this does not take away the right of that person to use the courts to prove his innocence. The issue here is that the person is not coming before the court and has fled the jurisdiction of the Indian courts. So on that particular basis, this attachment and in this particular legislation, the attachment and the subsequent forfeiture may in fact not be a very delayed phenomena if the person against whom this particular offence of forfeiture is declared a fugitive economic offender and because he doesn't present himself to the court. In general, yes, there's always been delay in court proceedings, and a number of the proceedings in courts are also delayed because on both sides there are a number of adjournments which are taken. In this case, that may not be the case because the other party may not be present before the special court.
Oh, absolutely. That is why it's so important to have a debate in Parliament before such harsh measures are really made part of the legislation. But Mr. Umarji, the press release says that the need for the ordinance has arisen as there have been many instances of economic offenders fleeing the jurisdiction of Indian courts. anticipating the commencement or during the pendency of criminal proceedings. This is true, but it's not as if we don't have means of getting the guilty to face the music. We do have extradition treaties with many countries, including the UK, with whom we signed an extradition treaty as far back as December 1993. So will the mere fact of confiscation, attachment, etc. serve as a deterrent? Because after all, most of these people are people who have made so much money, because as I said, the ordinance covers only those where the economic offence is over 100 crores, that will this really act as a deterrent?
Getting the orders of the courts in foreign countries would be a very difficult task, and we will have to establish in that jurisdiction that whatever actions are being taken are fair and reasonable, and the person is guilty of some criminal conduct, and for that reason the action is being taken. Then only the foreign court will pass an order for attachment of properties located in foreign jurisdictions, and the ordering the sale of such properties and paying the sale proceeds to the Indian authorities. This entire process is not going to be very easy, and it will be subject to many terms and conditions which are applicable in accordance with the law of the country in which the property is located.
Mr. Dixit, the PMLA was passed with as high hopes, but we've seen very few cases of successful prosecution under the PMLA. Why, and what must we do to ensure that the same fate doesn't meet the FEO bill?
So I wouldn't have the statistics about what are the prosecutions having not directly dealt with this. But the usual caveats would apply, which apply to all litigation in India, and like I had mentioned earlier, it is understaffing at the level of implementation, and also the fact that representation is many times is in most cases adjournments, and the lack of the number of special courts themselves, so that they have very high number of cases piled up before them. This is something which is which runs across all litigation in India, and needs a different kind of an approach, which isn't restricted just to the PMLA.
Mr. Umarji, the ordinance also says that the authorities can confiscate not only the proceeds of the crime, but any other property either in India or abroad, whether or not owned by the fugitive economic offender or not. Presumably, this is to guard against cases like what we heard recently about Tipu's sword that Malia claims is no longer with him. But in practice, is it not going to be very difficult to actually enforce this and confiscate property located abroad, Mr. Umarji?
It will be very difficult to enforce such a provision. It will be necessary to at least basically establish that there is some connection between the property which is sought to be attached and rights of the person over that property who is guilty of being a fugitive offender. So, unless that link is established, it will be very difficult to attach the other properties. But if we are in a position to establish that the funds acquired by committing the scheduled offence are utilized for acquiring that property, you are also in a position to establish that acquiring that property was done in the name of some third person who is connected with or close to the associate of the individual who is the economic offender. It may be possible to attach such property, but all these facts will have to be established to get hold of any other property which has no direct connection with the fugitive offender.
Oh, absolutely. So, though the bill is expected to re-establish the rule of law with respect to any crime where there is a fugitive economic offender involved, so that they would be forced to return to India to face a trial for scheduled offences, in practice what we are seeing is that the law may be much more harshly worded than was intended, and in practice it's going to be very, very difficult to actually enforce it. Thank you so much, Mr. Umarji and Mr. Dixit, for joining me in this discussion. Thank you also for watching. Remember, we'll be back next week with yet another edition of Macros with Mythili. Till then, it's thank you and goodbye from all of us at ET Now.